if it were a public utility. But the problem here is that they didn't really define in the act itself what they meant by public interest, convenience, and necessity. They left it very, very vague. And in fact, they left it up to the commissioners of the FRC to interpret that language. And who were the commissioners of the FRC? Well, I'm sad to say that they were all lawyers who worked for the big corporate, who at one time or another worked for the big corporate broadcasters. In fact, one of the most important figures in the early history of the FRC is this guy, Lewis Caldwell, who was actually a consultant to the Tribune Company about radio issues, was a lawyer who worked for Colonel Robert McCormick's law firm, Kirkland and Ellis, and was basically in the pay and on the payroll of the Tribune Company, and he was, he had a huge role in sort of defining how the FRC interpreted in the public interest. And so, because I know we're kind of short on time, I'm going to sort of fast forward here and say one of the first acts then that the FRC undertook after it was created was what's sometimes called, or what is called, General Order Number 40, which was essentially designed an order that basically suggested that there were two types of radio stations. There were the small, not-for-profit, non-educational, non-commercial stations. And it suggested that they should have less priority than the well-funded, wealthy stations that had the money to broadcast, to install state-of-the-art technology in their studios, and to produce state-of-the-art, cutting-edge programming. And so technological capacity, right, and really the capital at disposal of radio stations became this sort of dividing line. And stations that were classified as small, non-commercial stations that lacked technical capacity could be pushed around. Their place on the radio dial was changed so that they had to, say, take WCFL. WCFL had been broadcasting at 6:20 a.m. They were shoved to a different area on the broadcast spectrum to 6:10, and then later shoved over to I think it was 9:20. So they kept being moved around on the radio spectrum. It's very hard to build up an audience when your station is being moved all over the map. And secondly, those stations that were deemed to have technological capacity to do state-of-the-art broadcasting were given what's called a clear channel. That meant that nobody else could broadcast on their spectrum. Whereas stations that lacked technological capacity, like WCFL, would be forced to share spectrum with other stations. So in the case of WCFL, they actually had to briefly share a station or a channel with a station from Lane Tech High School. In response to this, there was, as you can imagine, a lot of outcry from the not-for-profit, non-commercial broadcasters, and especially WCFL and the leadership of WCFL actually led the fight to get this General Order 40 overturned. WCFL actually took some provocative steps. It applied, first of all, for a clear channel on the frequency that was being used by WBBM and demanded that there be a hearing about that. And then to get even more provocative, a few years later, in 1930, they then applied for the frequency for 7:20 a.m., which some of you may know is the frequency used by WGN. And they almost had a hearing about it. They got very close. They were very surprised when the FRC actually approved a hearing and then very quickly called it off at the last minute. But they took a lot of provocative steps because they felt like what the Radio Act had done was consolidate corporate control over the airwaves and marginalize the voices of educational broadcasters, labor broadcasters, and others. And Edward Nockels in particular made a number of speeches, visited Congress to testify to the effect that, that the Radio Act had actually consolidated corporate control over radio. All right, fast forward up to 1934, which is the next sort of significant piece of legislation that affected the public's access to the airwaves, and that's the so-called Communication. It's the Communication Act of 1934. In between 1927 and 1934, these activists, early media democracy activists, who felt like the FRC had been ignoring the public interest, started to lobby Congress in earnest. The ACLU got involved in lobbying on the behalf of what was called radio reform, and an organization called the National Committee on Education by Radio, which was an umbrella organization of all educational broadcasters, got together to lobby in Congress for substantial reform of radio. Because already by like 1930, it was clear that commercial broadcasting was already a vast wasteland. Long before the invention of television, it was already clear it was a vast wasteland, that radio airwaves were being used basically to sell soap and coffee and stupidity of various kinds. There was this sort of growing movement of people who wanted to change radio and reform it. The problem was, as so often the case, is they couldn't agree on how they wanted to reform it. You had different camps pushing for different sorts of reforms. One camp, led by the WCFL folks and Ed Nockels, were pushing for the creation of a true public service broadcasting system, like they had in Britain, where you have government monopoly over broadcasting, but the corporation that runs it is independent, and it's publicly accountable in various ways. And Canada, to kind of recommend this solution even more, Canada had recently adopted its own version of a public service broadcasting system. So there were people in the US who were pushing for something like the BBC here in the United States. There were others who were what we might call the more moderate faction of the media reform activists of the 30s, represented by the National Committee on Education by Radio, who simply wanted a certain number of licenses set aside for educational uses. Some of them wanted 25% of all radio licenses set aside for educational uses. Some wanted 15%. In the end, since none of the activists, none of these people who were lobbying and pressuring Congress for reform could agree on what they wanted, they got nothing. And what happened ultimately was the 1934 Communication Act basically made the provisions of the Radio Act of 1927 permanent. It replaced the FRC with the FCC, the Federal Communication Commission. But I do want to suggest that they did, these the sort of early kind of media democracy activists did get a few things from all of the pressure they brought to bear on politicians. One thing that they got was a fairly limited licensure period. So in the early days, broadcasters would be licensed for only 3-year stints. So they would have to renew their license every 3 years, and that meant that every 3 years, at least theoretically, the public had the right to kind of weigh in on their performance. Second, the Communication Act of '34 did have some antitrust provisions. Specifically, in the early days, a single company could only own 7 broadcast outlets, only 7 radio stations. And that was a pretty severe restriction, because this is at a time when when RCA is creating the National Broadcasting Corporation, the first radio networks, and they have the potential to extend those networks to hundreds of radio stations. If the government had allowed them to, they would have simply bought up hundreds of radio stations around the country and been effectively a private commercial radio broadcasting monopoly. So this actually